Hello everyone. Today we are going to do the group presentation of our case study. So we have selected the case Flavel V State of Essay 2009. So we are 5 members in our group and we are group number 46. And here is my friend Salina and Sumit. So we together are doing the group presentation. So now first I am going to discuss about the case introduction. This case was a crucial case of Australian history, which includes the emphasis on the degree of care needed in both the choices of the expert witness and the assessment of quality of the expert evidence. One judge of the Supreme Court of Australia, South Australia, first heard the claim made by a young woman who suffered an injury to spinal when she fell from the windsurfer at the aquatics camp held at the school. The injury sustained amid the race between the land windsurfers at the first dance. The trial judge figured out the respondent did not breach his duty of reasonable care. The trial judge figured out the area in which the accident took place was quite appropriate for the learners. In addition, appropriate safety equipment was on and the instruction was held pretty appropriate. The trial judge determined that the race did not enhance the risk magnitude. However, the full federal court determined that the race did enhance the magnitude of the risk to which the plaintiff was exposed. Full federal court carried in the analysis of the evidence and it was inappropriate to reject the appellant's expert evidence as to the risk appropriate. So now my friend Selena, she's gonna discuss the facts of the cases. Thank you.
Hi, I would like to start with the fact of the cases. The cases include a student which was injured being on the school camp at the Moorhunt Line Aquarium, which was owned by the state of the South Australia. The student undertook the windsurfing lesson conducted by the instructor. The students were needed to wear the safety equipment, including the life jackets, safety helmets, and the specific shoes for protecting their feet. The group of students were amid the second lesson of the learners windsurfing the classes. The students being the lesson required to participate in the races where they race one another the across. During the third section of the race among the students, one student was implanted in the case wearing the cement boat camp on the river's other side and feared that she may conclude with the boat camp and injured herself. Hence, attending to the the boat on, she lost her balance and fell in the water. The Supreme Court judge held that while the duty of care were owned by the defendant to the mainplate, the duty were never breached. However, the judge was overruled after an appeal by the complaint to the full federal court. Now I would like to start with the issues raised by the plaintiff and the defendant. The plaintiff school girl raised an issue that the state of the South Australia owned a duty of care where they took a student to the camp at the aquarium. She raised an issue that she placed the duty of care by asking the student to participate in the race. On the other hand, the defendant in the case claims an issue. The defendant claimed that they didn't breach their duty of care. They ensured the safety of the student at the camp at the Moorhunt Line Aquarium. In addition, they claimed that during the race they were liable for the injury caused by the mainplate and was because of the mainplate's own mistake. Now my friend Sumit would like to start with the agreement presented by both the parties. Thank you.
Hi, I'm Sumit. So here I'm going to tell about the agreements presented by both parties. There were several agreements presented by both parties in the case. First of all, the case was proceeded to the single judge of the Supreme Court of South Australia. The plaintiff agreed that the state of South Australia must be liable for the spinal injury caused to her participating in the race. She argued that she was asked to take a part in the race. The state of South Australia must have taken the preventive measures while conducting the race among the students in the camp. So here, the painful The plaintiff also agreed the state of South Australia must be liable for damages of the injury caused to her spinal. She argued that they must have performed their duty of care while taking the student of the camp, especially when conducting the race. They have bridged their student to the camp, especially when conducting the race. Her major arguments was that the state of South Australia forced her to participate in the race and punished to danger. This was because the race she suffered an injury, she was exposed to danger and risks at the river. The arguments were successful before the full federal court. The arguments presented by the defendant were not successful before the full federal court. Okay. And here on the judgment of the court, it says that the court gave a brief decision on the case and raised a few important points. The final decision of the federal court favored the plaintiff, the held in the South Australia liable for the injury caused to the plaintiff. However, the first decision was given by the trial judge of the South Australia Supreme Court. He judged the case in the favor of the defendant. So, the final decision of the case was given by the full federal court. The federal court determined the race did enhance magnitude by the risks of which plaintiff exposed. Full federal court entered in the analysis within appropriate to reject the appellant. Frequently, parties are looked with practically question-based experts reports, especially from engineers, giving supposition openly risk cases and booking figuring financial claims. It should be recollected that the acoustic fundamental the expert reports can and ought to be challenged in suitable case.
Hi, this is Mr. Constructor doing the critical analysis of the decision. The decision made by the federal court was accurate and precise. It must be determined that the decision by the full federal court was favoring the plaintiff. The court held the state of Australia liable for the injuries caused to the plaintiff because of the race. The expert evidence says that the magnitude of danger was enhanced by the race in which the plaintiff was asked to take part by the defendant. This decision must be agreed because of many reasons. The plaintiff had a pretty strong case against the defendant based on the fact of the case. The decision was based on the fact of the case which also favored the plaintiff, as she was asked to participate in the race that was likely to cause the injury to her because of the enhancement in the magnitude caused by the risks of race. The defendants did not have a very strong and compelling case. This is mainly because they had not ensured the safety of the students before the race. Even though they had ensured the use of safety equipment, however, the safety equipment was not useful during the race. The race was not conducted in the rightful manner, as the expert evidence says that it just increased the likeliness of the risks and the danger to the plaintiff. On the other hand, the plaintiff had a quite strong case and evidence in her favor. She had stronger arguments as compared to the defendant. The race had caused the injury to her because she had a favorable argument that the race increased danger to her and caused the spinal injury, as determined by the full federal court in 2010. The full federal court had also agreed with the arguments made by the plaintiff. The plaintiff was forced to participate in the race, which proved to be dangerous for her. There was no assurance of safety while conducting the race by the defendant. The plaintiff affirms the break of the defendant's duty of care to the plaintiff in negligence to give legitimate direction, causing or allowing the plaintiff and defendant understudies to take part in the race who is not appropriately prepared or talented to do as such. This caused the plaintiff understudies to race in a shallow bit of the river where there was hazard that the plaintiff may strike her head to the base of the river, utilizing insufficiently prepared windsurfing teachers, bombing sufficiently to regulate the plaintiff, and neglecting to give a satisfactory well-being hardware to the utilization of the plaintiff. So hereby we conclude our group assignment. Thank you.